Ghana for for any obi biara aha Ghanatube so modofo snowy any ebuzan for matana say maji akonye die no mehu say an ensem no edos ye pa eno ena mede boy say wonsom no eno eni nipa ebuzan for entempa no di mechie na ensem bia ewo ho ana say bia ekoso ewo manga nim no say memfa ensom di mechie.
Chief Justice Gertrude Tokono has formally written to President John Mahama and the Council of State for her to be provided with copies of the petitions against her. Citing Article 146 of the Constitution, the Chief Justice reminded the President that it was requisite for her to be notified of the various petitions for her to respond. She noted that the evidence contained in the petition, coupled with her response, would guide the Council of State to determine whether a case has been made for her to be removed.
There's a latest development to this that we're following, all of what we've been talking about. And let's see what the Chief Justice is demanding exactly. That is, if we do have it. The Chief Justice's letter to the Council of State, the President himself as well, she's making some demands. Let's get into the details of it. You've touched on it briefly, but specifically, what's she asking for?
Well, so these are the key lights of what the Chief Justice has been speaking about. I mean, that's contained in her letter. That a defendant cannot be subjected to a trial unless preliminary process of receiving their response has been adhered to. So this was the Chief Justice stating what the law is, based on which she was making the requests for the petitions and also an opportunity to make her input. Now she says that up to date, that's today, the Chief Justice hasn't been shown the petitions or allowed to respond to them. Again, she continues by saying that before a case could be made, it's a combination of things. So she explains that the combination of evidence in the petition and the response of the Chief Justice will provide material for consultation between the President and the Council of State. That is to say, even before the President could forward the petitions to the Council of State for the consultation to begin, they needed to have her make an input so that her input or her response, together with the content of the petition, would form the basis for their consultation. Again, she says that she wants that the petitions be forwarded to her and given at least 7 days after receipt of the petitions so that she can provide her response. There's an update on this because we have seen some persons from government seem to suggest that when the President forwarded the letter that accompanied the petitions to the Council of State, it included the question of whether or not the petition should be forwarded to the CJ, the Chief Justice, for her to respond to. That is to say, there is a consideration of whether or not this should even be allowed in the first place, and it's also part of the consultation that is ongoing.
Unpack the issues tonight, and we'll just do a quick recall, because it's just on Tuesday, 2 days ago, that we got notice from that statement that Phyllis Kwachofosu, the Minister in charge of Government Communications and also spokesperson for President John Dramani Mahama, detailing the fact that some 3 petitions have been received against the Chief Justice, for the removal of the Chief Justice. Now, the President, in following through the details of Article 1466 of the 1992 Constitution, was based on that statement, reported to have forwarded those 3 to the Council of State for the consultative process to begin. Now, it is this particular detail that was put out in that statement from Phyllis Kwachofosu 2 days ago that has generated a number of happenings today. A number of things have happened with respect to this particular information 2 days ago. We started off the day with a suit by the old Tafo Member of Parliament, Vincent Eko Asifwa, which was filed by his lawyer and the former, in the immediate past, Attorney General and Minister of Justice, Godfrey Yeboah-Dame, That's what we're going to start with, because after that, a number of things have happened. Dennis Barberi Wadam Esquire is with me in studio. Dennis, it's been a day full of legalese, is it not?
Well, it's been a long day, and it doesn't look like it's going to end tonight. We still have a lot more days to go.
There's a lot more to do.
Yes, and so like you rightly mentioned, we started off the day with this particular lawsuit by Vincent Asafua, and his contention is that the route that the president has taken in looking into the petitions that have been put before him for the removal of the Chief Justice, that route is unconstitutional, and that some processes ought to have been taken before the president could even refer the petition to the Council of State for them to begin the consultation process. So that really was the beginning of all the controversy, even beyond what we had mentioned on Tuesday as to how the committee itself, together with the president, are going to do their work with respect to determining a prima facie case.
That's right.
And even going beyond to now set up that committee to look into the matter. But of course, these are just a recap of the reliefs that Vincent is seeking in respect of this. So he says that he wants a declaration that upon the true and proper interpretation of Articles 146, and mind you, 146 is the provision that relates to the removal of Superior Court justices and the Chief Justice. We had gone through this before, but we'll also be looking at parts of it, because parts of it are in controversy, especially the 1466.
Right.
And also that Articles 146 and 296 of the Constitution. The President is mandated to notify the Chief Justice about a petition for the removal and solicit her comments. So the point that Vincent is making is to the effect that that letter that we got on Tuesday announcing that the President had forwarded the petitions to the Council of State for the consultation process to begin. He says that if you read the provisions together with Article 296, the President ought to have notified the Chief Justice about the pendency of the petitions and also to elicit some comments from her so that it will form part of the consultation that is ongoing. And to that extent that it wasn't done, it meant that he wanted the Supreme Court, or he wants the Supreme Court to declare that as unconstitutional.
So what? So before the president forwarded this petition, the three of them, the Council of State, the consultation or letting the Chief Justice know that, look, these petitions have been brought to my attention and these are the details of it, should have been done?
Yes, so when this suit came up in the public, there were questions as to how Vincent got to know as a fact that the Chief Justice was not notified and that she did not get the opportunity to comment on the matter. However, as the day went by, we got answers to that question.
Indeed.
Because later we would show a letter from the Chief Justice herself to the President, and then the Council of State requesting that she be notified officially and also be given the opportunity to comment on some of the things that are said to be in the petitions. She wants to have a look at the petitions as has been put in this lawsuit as well. So that answer clearly is there.
But maybe that brings up another question, which I know you probably will give us an answer as to whether Article 1466 specifically states explicitly that the Chief Justice should be notified of the details of the petition at any point.
Right. So that's, yes, we can also look at it. But remember, in crafting the reliefs, he does not just leave it at Article 146. He adds another article, 296. Even when you look further, he adds another one, 23. And 23 and 296 are key when it comes to administrative justice. He does so because, in his view, when the President together with the Council of State are doing the consultation, they ought to be mindful that they need to be fair to the persons whose rights are going to be affected. And in doing so, he says that they should have read their minds to Article 23 and 296. So that's how come you may not see that expressly stated in 146, but when you look at these put together, you may come to that conclusion. Well, that's the argument he's making as to whether the Supreme Court will be minded to go with him or not. It's a matter that will be determined on a future date. But just to understand why he does not just leave it at 146 and why, if you look at 1466, you may not find that provided in there expressly. that is the reason for that one. So just to continue with the recap that I was doing, he says that because the president failed to do so, that's notify the CG, it constitutes a violation of a fundamental right to fair hearing contained in Articles 23 and 296 and renders the consultation processes for the removal of the CG initiated by the president now void and of no effect. So in effect, he's saying, for the fact that you did not do this before you announced to us that this process has already started, it constitutes a violation of her human rights because she's entitled to fair hearing.
Right.
So,
and the fair hearing captured in that demand that even before these petitions were forwarded to the Council of State, the Chief Justice should have been heard.
That is her view. I mean, that is his view. And of course, when you look at the letter that has been written by the Chief Justice herself to the Presidency and the Council of State asking for a copies of the petitions and also asking for the opportunity to make her comments, she did indicate that yes, when you look at our jurisprudence, it is a practice that anytime something of that nature comes up, there has to be an opportunity for the person to be notified and also for that person to also comment. She cites instances where she herself as Chief Justice. Remember, when you look at Article 1463, which makes provision for the removal of the justices of the superior courts, the petitions typically are referred to the Chief Justice, who makes a determination of a prima facie case. She says that in her case, at least, she has had opportunity of presiding over 5 of them. And in each instance, she has notified the persons involved and given them the opportunity to comment.
Yo for yako aba ute insem no ese ode anase anya ode dey ene wadwintre fa wadwintre no ewu kimi comment section no na menje bre enkinkan emofefe aha Ghanatube so ebusianfo sisiade my crown.